I'm Ken Carlson. I've been an attorney helping tenants since 1980. I operate the caltenantlaw.com website, where you will find this and other helpful videos about your rights as a tenant. In this video, I'm going to talk about the demur phase of your eviction case. Here on the game board, you see a number of steps that it can involve, which I'll discuss, as well as the various grounds for a demur that might apply in your case. In the total picture, the demur can add 3 to 6 weeks of extra time before your trial, even if it is not successful. If it is successful, it can result in the whole case being decided in your favor, or the landlord having to start over with a new complaint. In the motion to quash phase, we said that the UD packet was not served properly. In this phase, the demur says that you are not being accused properly. It's not your side of the case. That comes in your answer later. Eviction cases are very tricky, with lots of special laws, rules, and procedures that have to be exactly followed. We find all the mistakes that the landlord's lawyers made and bring them to the judge's attention by the demur. There are a few different types of demurs that may apply to your case. Most are for failure to state a cause of action. That's the technical term for making a mistake in the way they accuse you. The demur can be filed because there are conflicting statements made or uncertainty. It can be filed because the person suing doesn't have the legal authority to sue. There are over 100 ways that the landlord's complaint can have mistakes, even though it's a simple check the box, fill in the form kind of thing that any idiot could do. I won't bore you with all of these because maybe only one or a few apply to your case, but you need to understand what we're talking about, so I'll give you a few examples. It can be an eviction notice that's missing legally required words like the name of the person to pay. It could be that you're renting an illegally built house or converted garage. The person evicting you may not be the real owner or not have the legal authority to evict you. The case could have been filed too soon or against the wrong people. It could be based on an unsigned rental agreement or without a permitted reason under the eviction protection laws. 99.9% of the eviction cases face a demur. It takes a lawyer specialized in landlord-tenant law to catch these technical defects, so it's not the kind of thing you could do on your own or even using a paralegal or AI chatbot. You just need to know that you have this additional way to win, or at least slow down your landlord based upon technical situations. So, you get the demur written up and ready to file. The demur has to be filed after the motion to quash period and within the deadline. In the typical situation in our game board, that deadline arrives 15 days after the appellate court has mailed their denial of your petition for writ of mandate. Just like a motion to quash, we get a hearing date for the demur. Just like the motion to quash, based on the courthouse, we can either set that date on our own, or we have to get the court clerk to set it. Just like the motion to quash, you submit on the papers and don't attend the hearing. The demur is filed in court and sent to the landlord's lawyer. The hearing is supposed to be 5 to 7 days after it's filed, but the court clerks usually set it later because they have too many cases. Sometimes it's filed too far ahead, and the landlord files an ex parte application to shorten the time for the hearing. And you can file an opposition to that. There is a hearing on that ex parte application, but you don't attend. Instead, you check with the court clerk the next day to find out what happened and preferably get a copy of the minute order which spells it out. the judge may not only grant the application to shorten time, but rule on the demur right then. The landlord's attorney might file and give you a written opposition to the demur, defending the defective complaint. Usually, they skip the writing and just tell the judge at the hearing why it should not be granted. That way, you can't be ready for or respond to their ridiculous opposition. If you do get a written opposition, you can prepare and file and serve a reply to it, explaining why the landlord's lawyer is wrong. If the landlord's lawyer agrees with you about the mistake, he can go back and file an amended complaint that supposedly fixes the problem. So you can cancel the first demur hearing and maybe file a new demur to the amended complaint. If the judge agrees with you, the demur is sustained, and if he disagrees with you, it is overruled. The mistake of the complaint can be so plain and unfixable that the demur is sustained without leave to amend, meaning you won because the case is thrown out. Usually, the judge will give the landlord a chance to fix the complaint, and it is sustained with leave to amend, giving about 10 days to submit the amended complaint without that mistake. The amended complaint could also have problems, and you could file a new demur to that. If the judge overrules your demur, which they usually do without even reading it, you are usually given 5 days to file your answer, counting from when and how you get notice of that ruling. It's important for you to understand that the judge overruling your demur does not mean that you've lost on those issues. It only means that the complaint is not so defective that it has to be rewritten. Since the demurrer cannot consider any of your factual defenses or evidence, it could not be a determination on any of the real issues for trial, because the judge only had half the story. If you do attend the hearing and the judge overrules the demurrer, you want to be sure that you say that you do not waive notice. Even though you're standing there listening to the judge ruling, you are entitled to a written notice expressly telling you what the judge ordered. There are 2 reasons for that. The first is that you can then share that notice of ruling and even the minute order with us, so we can see how the judge ruled and any possible mistakes. For example, if the one who made the ruling was the judge you rejected, or a commissioner or judge pro tem to whom you did not stipulate, the ruling is illegal, and we can get the appellate court to order a new hearing and even more time for you. The second reason is the extra time you get to answer, especially if you still have discovery pending. If you attend and tell the judge that you waived notice, your 5 days to answer starts right then. However, if you don't waive notice, or don't even attend the demur hearing, you get 5 more days from the mailing, or 2 more days for overnight mail, or if delivered to your house, 5 days from that delivery. With that, you are finished with the demur phase of the eviction case, and your next step is to file your answer, finally giving your side of the case. Hopefully, by that time, you have completed your discovery, or are close to it, in order to have the best defenses ready for your answer. Keep in mind that even if you've lost every motion up to this point, you've gotten more time to complete your discovery, look for alternative housing, get a new job, or whatever. You have been winning in real terms. The landlord knows that and sees you dragging this out, costing him a lot more money, and not being afraid of him as he had hoped. More than that, the demur has revealed a few weaknesses in his case that he hadn't thought about, and his lawyer has explained that he could lose the case if this case gets to trial on those things. He is getting nervous about what he initially thought was a sure thing, and recognizing that his bullying is backfiring badly. He wanted a fight. He got one.